Good morning. This is JP Sarmiento of Sarmiento Immigration Law Firm. For today's success story posting, May 18, 2020, it's an immigrant visa approval for two kids based on an approved I-130 immediate relative petition. Kids were born out of wedlock, so that's the special part of the petition. In fact, the last name of the kids on their birth certificates are not even the biological father. Instead, it's the husband of their mom. But it's the biological father who was in Daly City, California, suburb of San Francisco, who filed the I-130 petition. So in a case like this, what's important is not just to show that you're the biological parent, but that will eventually be determined through a DNA test. But you must show also, and this has been prevalent with CIS over the last 5 years, just active parent-child relationship during the youth of the child. Whether you support them through school, send them money, visit them, have pictures together, stuff like that. So our client, so we filed the petition on June 8, 2018. And then everything went smoothly. Those documents were submitted. And there was a request for evidence for the DNA test. So, which is, normal and actually mandatory in a case like this where the kids were born out in wedlock. So that was expected. So our client underwent the DNA procedure, and then eventually on February 19, 2019, the I-130 petitions were approved. And so we initiated the immigrant visa process. Took some time before our client obtained the documentation with the affidavit of support and NBI clearance, the police record from the Philippines. But ultimately, on September 17, 2019, we filed the immigrant visa package to the National Visa Center. And then an interview was conducted for our clients in November. And then on February 10, 2020, the U.S. Embassy in Manila approved the immigrant visa packets for our clients. Corona, this whole COVID-19 thing happened around March, but they're physically here in the U.S. as of last week. Our client emailed us. So, that's that's something good. But at the start, it seemed vague for our client. The kids were born out of wedlock. His last name was not even on the birth certificate of his kids. But as we mentioned, if you show that parent-child relationship, which they had, and if he's really the father, in which case he really is, with all the DNA testing and possible responses to requests for evidence, it's a case that should be approved, and it was. So if you have any questions pertaining to something similar or anything immigration related, feel free to contact our office, JP Sarmiento, Sarmiento Immigration Law Firm. Our consultations are free. 216-573-3712. You can also email me at jp@sarmientoimmigration.com. Thank you.